So as Margaret mentioned, we're here to talk about claims against state officials post-Godfrey. When the Godfrey decision came out in 2017, it was a real watershed event. Even though it was multiple years in the making, numerous plaintiffs' attorneys had tried for years bringing cases against school districts, the state of Iowa, other municipalities, to get recognition of a constitutional cause of action directly under the Iowa Constitution. The closest they had previously got was in the Renda decision, which was ultimately affirmed, however, 3-3 by the Iowa Supreme Court without an opinion, since they were tied. So while the issue had been raised before, it had never previously been decided by the modern Iowa Supreme Court. And I say modern Iowa Supreme Court because, as Godfrey noted, some of these issues had been adjudicated early on in the 20th century and then promptly forgotten by generations of lawyers and judges alike. So, let's get to what the Godfrey case actually is. Christopher Godfrey was the Iowa Workers' Compensation Commissioner. He was appointed by Governor Culver in 2006. 2006? I believe so, for a 6-year term. 2008 for a 6-year term. His term is supposed to last until 2014. When Governor Branstad was elected and started his tenure in 2009, he sought Mr. Godfrey's resignation. Mr. Godfrey refused, believing that his appointment was non-political and that he had a right to the appointment. Instead of terminating Mr. Godfrey or otherwise leaving his position alone, it is alleged that the governor took Mr. Godfrey's salary, which then was at the highest end of the pay range for his position at approximately $112,000 a year, and lowered it to the lowest amount in that pay range, approximately $73,000. After that, Mr. Godfrey filed suit, naming more than a dozen different individual counts and naming many members of the governor's staff. And you won't believe this case has gone up. I believe it's had 3 motions for summary judgment. It's gone up to the Iowa Supreme Court twice in the intervening years. First, on the issue of what it means to be in the course of employment for government officials, and then in 2017 on this issue of whether or not there is a direct cause of action under the Iowa Constitution. It's interesting to note at this point, until we get to the end, that of course this was decided in 2017. It's almost 2019. This case continues to go on. It has not had trial yet. If Mr. Godfrey only served out a couple months after his salary was reduced before he accepted a different position, so the actual harm to him was approximately $30,000 or less, his term would have ended in 2014, and we would have had a new workers' compensation commissioner. Instead, we are approximately a decade into this lawsuit with very little actual movement, but hopefully a resolution on which causes of action are alive in this case. So the 2 causes of action that Christopher Godfrey attempted to bring were a direct cause of action under the Iowa Constitution's Equal Protection Clause and the Iowa Constitution's Due Process Clause. Now, I can tell you the holding of Godfrey very simply. How we get there and the justification for how we get there, however, is very confusing because there are 3 different opinions in this case. Justice Apple writes what purports to be the majority opinion. And for large parts, it is. And Justice Apple, after going through a large historical analysis, determines that the Iowa Constitution is self-executing, and you can bring a direct cause of action under the Iowa Constitution. Or at least I should say, it's potentially self-executing. He then determined that both the Equal Protection Clause and the Due Process Clause were both self-executing. However, that's where Justice Apple loses a majority is after the next step. Because the next analysis after that is whether or not there already exists a comparable statutory civil remedy for violating the Iowa Constitution. And this is where Justice Mansfield's dissent and Justice Cady's special concurrence hold the majority. And in that decision, it was determined that the Iowa Civil Rights Act is a comparable civil remedy for equal protection violations in the employment context. Obviously, there are many different contexts for an equal protection violation. So that's the simple holding of Godfrey. How we get there, as I said, was very complicated because you literally have to go paragraph by paragraph of the Iowa Supreme Court's decision and write how many justices agree, paragraph by paragraph. Now that is very difficult to do. Now when this case came out, I think because of the multiple opinions, it was overwhelming as a watershed case and difficult for people to understand. And I think part of what we're trying to do today is to pull back from Godfrey and this idea that there's a private cause of action under the Iowa Constitution and really look about what you do when you have a Godfrey case come to you. When I first read Godfrey, I thought we were going to spend the next 10 years litigating on what constitutional causes of action were self-executing. So I tried to find the test. How do we determine if a cause of action is self-executing and there is a cause of action? Despite the fact that this is a very long decision, the actual test is really rather simple. And it is buried, I think, in the most important paragraph of Justice Appel's decision. And that is under number 3 in the discussion section, under standard for determining self-execution. Justice Appel quotes and accepts the federal standard for self-execution. So a constitutional provision may be said to be self-executing if it supplies a sufficient role by means of which the right given may be enjoyed and protected, and it is not self-executing when it merely indicates principles. He went on to add 2 different additional provisions, that the provision itself does not contain a directive to the legislature to pass some sort of enabling legislation, and that the constitutional provision take effect immediately upon enactment. So in short, Justice Appel says, if the constitutional provision is complete in itself, it executes itself. Well, those are nice words, but it's a hard test to come up and to understand from that test, so to speak. I understand the first prong, the idea that doesn't contain a directive for the legislature, that's easy to determine. For example, if you look in the election sections of the Constitution, it says the elections shall be set by rules adopted by the legislature, things of that nature. There are clear directives to the legislature to set standards offering details to a constitutional provision. There is, of course, no such directive in the equal protection or due process clauses. However, under the rule, something is not self-executing if it merely indicates a principle. And I personally have a hard time figuring out what is so clear and self-executing about the due process or equal protection clauses. They are not like a constitutional provision that says the president shall be 35 or Iowa shall have 50 senators. Those are obviously very clear and don't require any further illustration to understand what those provision means. Anyone who reads them understands them. We don't need a comparable statute that says the president has to be 35. But what due process means and equal protection means, in my opinion, not the Iowa Supreme Court's opinion, express more of a principle that has evolved over time. However, as I said, the Iowa Supreme Court disagreed and found those 2 provisions to be self-executing. So that is the test. And as I said, it is simply a paragraph. But that is what you should do in the first step of any time you get a Godfrey case, is look at the particular constitutional provision that's being asserted. Is that constitutional provision self-executing? How do we know that? And Justice Apple does go through an analysis of applying the self-execution standard to the due process and equal protection clauses. However, if you look at his analysis, it really goes into it's self-executing because courts have applied these clauses traditionally in the past in a myriad of different cases. That is undoubtedly true, but of course never in the context of a constitutional private cause of action. So I'm not exactly sure what to make of that analysis. I can't really get heads or tails on it other than if it's a constitutional provision that we well understand and its standards are somewhat articulable, then we believe it to be self-executing. Julie, do you have any thoughts on that?
I too have struggled with the idea that the test set forth in the opinion gives us much guidance on what to do in future cases. I also, like Megan, struggle with the idea that the two provisions that the court found were self-executing, indicate anything other than mere principles. I mean, while great principles and important principles to our society, they certainly don't set forth a sufficient rule by means of which a right may be enjoyed and protected. And I think that's evident by the cases that follow Godfrey, and I think the years of litigation that will undoubtedly ensue.
Yeah, it's been, as Julie mentioned, there have been many cases post-Godfrey, and what's interesting to me is they have not been discussing whether or not the constitutional provision at issue is self-executing. If you look at cases that we'll get into a little bit further on, the Baldwin case, for example, discussed Article 1, Section 1 of the Iowa Constitution, which I don't know if all of you have your Constitution in front of you, but that's referred to as the Natural Rights Clause.
You don't have it memorized? I don't.
I don't anymore, but it has some peculiar language in it that is very similar to the Declaration of Independence. It talks about inalienable rights. You have the right in Iowa to both seek and maintain happiness, to be safe. It's unique. It also hasn't really been interpreted that much by the Iowa Supreme Court. So what does it mean? What substantive right does it give people, and who? Is it the government that has the obligation to give that right? Are you just not allowed to infringe upon my right vis-a-vis other private citizens? I don't know. But the issue in Baldwin is not whether that provision is self-executing.
And we don't have the full case history of Baldwin, and I don't know if that was an issue that just wasn't raised on the certified questions to the court. But that is certainly something that I had intended to raise later, that Godfrey was about Section 6 and Section 9 of Article 1, and Baldwin, like Megan said, was about the Natural Rights Clause and the Search and Seizure Clause. Now, whether or not that was an issue that had already been raised and decided by Judge Bennett in the Baldwin case prior to it getting to the court, I doubt it, given that Judge Bennett has seemed reluctant to make any big decisions, if you will, without the guidance of the Supreme Court, given that this is such a new cause of action. So for whatever reason, it appears that the attorneys representing Esterville and the police department, or the police officers, excuse me, chose or decided not to raise the issue of whether or not those sections of the Iowa Constitution, Sections 1 and Section 8, are self-executing to create a cause of action under the Iowa Constitution. And I think the second factor that you need to think about in Godfrey is if they are self-executing, is there a comparable statutory remedy that is sufficient enough that a cause of action under the Iowa Constitution is not necessary? And I think Megan will talk about that next.
The test for whether or not there is a comparable civil remedy and that it's not necessary to find a cause of action directly under the Constitution is actually found, I think, in Justice Cady's special concurrence, or concurrence in part and dissent in part. Now, if you read closely, I think he's only talking here about the Equal Protection Clause. And what he says is that you have to first, to determine whether or not there's a comparable civil remedy, you have to look first at what kind of harm is being alleged here. And he found the harm in Godfrey was mostly monetary. Then he went on to discuss that there's also an emotional distress aspect about that too. So then he compared the Iowa Civil Rights Act and what kind of damages are available. And of course, monetary damages and emotional distress damages are available. Attorney fees are also available, which Chief Justice Cady found was relevant. The substantive difference, however, between a judicially created cause of action and the Iowa Civil Rights Act was the availability of punitive damages. Punitive damages are not available for 216 violations. And Justice Apple, in his decision, found the unavailability of punitive damages to be very important, and that in and of itself made the Iowa Civil Rights Act not a comparable alternative. However, Chief Justice Cady disagreed and said that in and of itself didn't make the Iowa Civil Rights Act non-comparable. And as a whole, he believed it was. That test, the type of damages, attorney fees, etc., however, was only relevant to Justice Cady for equal protection violations in the employment context. He goes on in a subsequent chapter to leave open the idea of that what is an appropriate civil remedy does depend on the constitutional right that is claimed to have been violated. So he goes on to say that in other cases, punitive damages may in fact be necessary. And he distinguishes cases that involve an infringement on physical security, privacy, bodily integrity, or the right to participate in government. I assume there are other violations that he could find. I don't know what would be necessary in those cases. It is really an open question whether or not purely the recovery of monetary damages and or attorney fees will be sufficient in the future for a comparable civil remedy. We just don't know. But it does leave the question open about whether the court would find a comparable Section 1983 cause of action sufficient in Iowa for all constitutional claims.
Yeah, and it doesn't seem from the decision from either the majority or the concurrence by Cady that there's a specific test for determining whether the remedies are sufficient, and I think that will be an open question. It's certainly something that if you are defending one of these claims that you should think about and raise. I think Megan and I come from a background of administrative law, and oftentimes we were challenging a separate lawsuit versus a 17A judicial review. And there's a bunch of case law about whether or not remedies are sufficient in that context. I don't know whether or not the court will rely on those cases that say, you know, even if monetary damages, it's only been 9 months and I've already forgotten. But, you know, whether or not the lack of monetary damages or even attorney's fees is sufficient to say that the remedy isn't enough. So that'll be an interesting area that will have to be developed. If that factor is to mean anything, if the factor that if there's a significant enough statutory remedy, if that is going to mean anything for determining whether or not there's a need for a separate constitutional cause of action, we'll have to see.
So I think, you know, while Godfrey is very complicated and will take a long time to sit through and delve into all three opinions, the vast majority of which don't actually announce what the law is, Julie and I think that we have developed kind of a three-step question to do if you get a kind of a Godfrey type claim. And the first, as we said, what constitutional provision is at issue in this case? What is being alleged? Second, is that provision self-executing? And third, is there an adequate civil remedy already available?
And I think the court specifically distinguished civil remedy from statutory remedy, and I think we had that discussion yesterday. The court specifically said statutory remedy, so it's unclear whether if there's a comparable civil tort claim, if the court would consider that adequate. They didn't really address that question in the Godfrey decision, but again, it's certainly something to think about.
And that's frankly where I thought the litigation was going to go after Godfrey. The Iowa Supreme Court hasn't had an opportunity to address any of these cases, except as it came up very briefly in one of the many automated traffic enforcement cases. In Weisberg versus City of Des Moines, which came out in August of this year, Justice Apple, again writing for the court, was dealing with the district court's dismissal of the multi-count challenge to the automatic traffic enforcement. And 3 of those counts were direct causes of action of the Iowa Constitution. The district court had, as most district courts had until Godfrey, dismissed claims brought into the Iowa Constitution. Justice Apple, in a very short paragraph, summarily reverses the district court, finds the Iowa Constitution to be self-executing, and sends it back for litigation on those claims. What I found interesting, however, in Weisberg was that there were 3 constitutional claims at issue. The first 2 were the due process and equal protection claims that were raised in Godfrey. The court had already determined those were self-executing, so no surprise there. However, without discussion or analysis, the Iowa Supreme Court sent back Weisberg's claim that under the Privileges and Immunities Clause. There was no discussion about whether or not that clause was self-executing, whether or not there was a comparable civil remedy. Maybe the Supreme Court decided to let those issues go back to the district court because the law had changed, and then to apply Godfrey. It's not very clear, but there wasn't a lot of substantive discussion.
And I think just as a sum up for what we can learn from Godfrey in terms of how to defend these claims, I think we need to realize that the question of punitive damages is left open. So if you receive a claim that seeks punitive damages, that should be an issue that is at least raised to preserve it. And also the question of attorney's fees. I mean, historically, the court has said we're not going to award attorney's fees unless there's a statutory provision that awards attorney's fees. So I don't know, Megan, do you have any thoughts on what the court will do in terms of attorney's fees for a constitutional claim under the Iowa Constitution?
Well, I mean, as Julie said, this is an open question. I, however, would point you to, again, Justice Apple's opinion in the Botsko case, which says that Iowa has always followed the American rule. We don't allow attorney fees unless there is explicit statutory grant of attorney fees, or whether or not is a contractual requirement for attorney fees. You can look subsequently to that, I believe, in the 3rd and 4th Tina Lee cases, where this was kind of tweaked because it was a claim originally brought under the FMLA, but then the state's immune, so it was an In re Young claim. But does that mean they get attorney fees? Because it's a quasi statute, but it's really a judicially created cause of action. Highly confusing. I would say no. I would certainly raise the argument that attorney fees are not available. This is a judicially created cause of action. There is no right to attorney fee recovery. I believe that should win. Whether it does, I don't know. I think it's going to be complicated in cases like Godfrey, where there are multi-count claims. So how you in Godfrey, like the court struggled with in Tina Lee, divide up what type of work and how much time was spent on the constitutional claim versus what was spent on other statutory claims, that gets very difficult, especially if something goes to trial and an appeal, when all these issues are meshed together. But definitely, I would preserve the issue.
And I think the last remaining question is the changes of the composition of the Supreme Court since Godfrey. Apple wrote the majority with Wiggins and Hecht, and joined by Katie for whether or not an adequate remedy existed under the Iowa Civil Rights Act for the equal protection claim and for the due process claims. But I think the question now is, how will this law develop given we have a new justice in Justice Christensen and with Justice Hecht's retirement this month. So I think those developments on the Supreme Court will make for a very interesting area of development of this law. I mean, Godfrey is so new. There hasn't been a lot of cases applying Justice Apple's majority decision, and whether or not he has enough votes to keep going down that road, I think will have to be seen. And I think that point, the composition of the court, is an interesting one when you go to the Baldwin cases that we're going to discuss as well. So Baldwin is, unfortunate that it's the next line of case, all from driving an ATV within city limits, but a man named Baldwin was driving an ATV within the city limits of Esterville. There were complaints. The cops reviewed the videos. They reviewed the statutes. They thought the ordinances. And he was ultimately arrested pursuant to an arrest warrant. But as it turns out, the city had adopted Iowa Code Chapter 321. However, they had not adopted Iowa Code Chapter 321I, which was the source of his ordinance violation. So the charges were ultimately dismissed against Baldwin, and he filed suit. He brought a Fourth Amendment claim under 1983. He brought a common law false arrest claim, and he brought a cause of action under Article 1, Sections 1 and 8 of the Iowa Constitution. So Judge Bennett, I guess I would say Baldwin 1 in your materials, although it's actually Baldwin 2 because there was a previous ruling on summary judgment, but it's the 2017 case that was provided in your materials. Judge Bennett dismissed the 1983 and the common law claims because he found that the officers were acting on a facially valid warrant, and that it was not clearly established that the conduct did not violate the ordinance. It's interesting considering there was no ordinance, and it gets more complicated in the following Baldwin cases. But then Judge Bennett reserved judgment on the state constitutional claims pending Godfrey. He did not address the first question that Megan and I had talked about, and that is whether or not Sections 1 and 8 are self-executing. He didn't address question 2 in his certified questions, and that is whether or not there's an adequate statutory remedy for those violations. So he certified the question simply of whether defendants can assert qualified immunity as a defense. And it becomes apparent in the later Baldwin cases that at this point the only defendant left is the city of Esterville itself, which we'll talk about later kind of becomes another issue. But so the certified question was, can defendants assert qualified immunity as an affirmative defense? And the Iowa Supreme Court, in the decision filed in June of this year, interestingly, now we have a swapped court. We have Mansfield, who wrote the dissent in Godfrey, is now writing the majority opinion of the court. And we have Apple and Hecht filing the dissenting opinion. So a little bit of a switch there, but the court ultimately answered the certified question is yes, that it is available as an affirmative defense. They go through a dissertation on other state standards and whether or not they followed the federal standards or state tort standards. It's rather long and really uninformative when it comes to what we need to do for Iowa cases. However, it's there if you need some reading materials to put you to sleep. However, in the end, the court does create a standard that neither party had asserted, that neither party had briefed, and that, as far as I can tell, wasn't used in any of the states that they talk about for, tens of pages. They create this standard, all due care. What does that mean? What does all due care mean? Does all due care mean something different than just regular due care? I don't know what the significance is of the addition of the word all, if any, but it's certainly there. So at some points in the decision, the court equates due care with objective good faith. Megan and I had a discussion about this yesterday. I'm not really sure what objective good faith means, given that I think good faith is whether or not I was acting like what my subjective beliefs were in. I don't know if you have anything to say about objective good faith, but the court does equate.
Well, and it's interesting that the court did adopt that when the court has declined in the Klein case to adopt a good faith exception to the warrant requirement anyway. So there could be some interesting analysis there that you might survive a suppression motion but then not have a constitutional claim for monetary damages for the same violation. So Baldwin is good news for government in the sense that there is a form of qualified immunity for government officials available under Godfrey causes of action. I think it is difficult and adds uncertainty because I don't know what the standard means. I only know that it's not the federal definition of qualified immunity.
Yeah, and the court does tell us that the federal standard of a clearly established constitutional right that a reasonable person would have known is too much. That the court is pretty clear that that standard gives too much to how clear the underlying constitutional law is, and the court rejects that prong of the federal standard, the prong of is the right clearly established. And Mansfield does say that whether or not all due care exists requires a more nuanced analysis. He doesn't give us much direction on what that nuanced analysis should look like, other than it requires more than that. He does say that factual good faith may compensate for legal error, and factual bad faith may override lack of clarity in the law. So those are two pretty good standards that he has given us, or at least grounds to argue. If we're trying to argue about all due care, and I think it's pretty clear from their analysis that if you're going to try to rely on federal precedent about, whether or not it survives under the federal standard, that's probably not going to be enough. You could use that as perhaps persuasive authority, but you're going to have to do more than that. At another point of the analysis, the decision equates all due care with proof of negligence, i.e. lack of due care. And in Apple's dissent, they also refer to he also refers to all due care as negligence immunity. So for what it's worth, those are the clues that they've dropped with us in this Baldwin decision. It apparently wasn't enough for Justice Bennett, or Judge Bennett, because he, as you'll see in the next case, sends it back down for more certified questions. I think the unknowns from this case leave us with whether or not this all due care standard is an objective or a subjective test. It's not entirely clear to me. I think the objective standard seems to be a little less important than the subjective standard with Mansfield's discussion of the nuanced analysis of good faith, bad faith. But I don't know. Do you have thoughts on objective versus subjective?
I don't, because I think he says both at various times. I mean, he uses the word objective, but then when he talks about factual, belief and factual good faith, well, that is most certainly subjective.
And I think it's also important to note, like, the scope of the Baldwin holding. This was basically a search and seizure case, right? Thinking what I'm trying to figure out now.
Yes.
Yeah, search and seizure case. So it was under Section 8 of the Iowa Constitution. And somewhere in the opinion, which I should have written down for you, the opinion specifically states that mens rea for claims other than search and seizure claims may be higher and may require intent. So, and that goes in line with what Megan was talking about earlier with the Supreme Court's refusal to allow a good faith exception to the exclusionary rule, that maybe this line of search and seizure cases will be an anomaly in terms of constitutional analysis, but that will be decided on another day, I think.
What's interesting about that is in the entire Baldwin discussion, as we mentioned before, and as Julie just said, they take it as a search and seizure case. They take it as nothing more. And if you look at Godfrey, they certainly discuss that it's clear to infer from the majority opinion that search and seizure violations were going to lead to a cause of action for monetary damages. The cases that I referred to from the early 20th century were all search and seizure violations. That's not surprising. What is surprising about Baldwin, as we mentioned, is it also brings up Article 1, Section 1. And there is no discussion in the court about that as listing as a cause of action or how this qualified immunity applies to that section.
And you'll see in Bennett's next Baldwin decision that he basically says there's just one cause of action that they're being raised, that he's relying on both sections of the Iowa Constitution to say that his arrest was unconstitutional, but he didn't even analyze them separately. So, and I think just wrapping up this Baldwin case, a further unknown is immunities. There was some mention in the case about the immunities in Chapter 669 and 670 and whether those apply. Interestingly, Apple's dissent reads the majority opinion as those immunities set forth in 669 and 670 might apply. Megan and I have been discussing these cases over the last couple of days, and it's really interesting to me when the court is very adamant that you can't restrict the Constitution by statutory inaction, and then in the next argument they say, but wait, that should be set by statute or limited by statute. So I don't know, this is a wide open area of law that's going to have to be figured out, but it is important when you're defending one of these claims to think about those immunities that are set forth in the State Tort Claims Act and the Municipal Torts Act.
I think it's also what's left open here is the other constitution or the other common law immunities that generally apply in the federal context, such as absolute immunity for prosecutors, judicial immunity for judges, and for other officials acting in judicial capacity. Now, quasi-judicial immunity. What's interesting and qualified immunity has always been kind of a mixed bag in the federal courts. It was always difficult to get out on a motion to dismiss on qualified immunity. It was a rare case where you could get out on a motion to dismiss under that. So it's not surprising that the Iowa Supreme Court calls that an affirmative defense. However, absolute immunity, judicial immunities have always been considered immunities not just from liability, but immunities from suit, and always raised and decided on a motion to dismiss. And I think that's significant because obviously it cuts the cost of litigation for government dramatically. So we don't know yet, based upon these line of cases, whether or not the Iowa Supreme Court will recognize those immunities, whether or not they'll have similar tests to the common law or to the federal jurisdiction, and whether or not they will be deemed affirmative defenses or immunities that can be raised initially upon the first pleading.
And the Baldwin case does indicate that it is possible that those immunities may apply, but again, does not decide those issues. And I think it's important to note as one last point, Apple's dissent, again, it was Apple and Hecht, so it's unclear whether he would be able to get the votes for this if it comes up in the future. But Apple does advocate for the abandonment of Monell liability. for municipalities, for that municipalities should be liable for the constitutional torts of their employees on the theory of respondeat superior. As you know, under Section 1983, they would not, absent a customer policy. So Apple advocates for the abdication of that liability. I'm losing my words. But then says, after he says we shouldn't adopt that, but that issue wasn't raised, so we'll save that for another day. But so it's definitely an indication that should Apple be able to gain the votes, that municipalities would not have Monell.
And I think Baldwin comes at a time that the Iowa Supreme Court is really tracking what's happening nationally on the legal front when it comes to 1983 generally. There has been a movement on both sides of the political aisle, frankly, that 1983 immunities have gone too far, and that these immunities have basically swallowed up federal constitutional claims. So it's not surprising that the Iowa Supreme Court is struggling with how to adopt these for our newly recognized state constitutional claims. So how that will play out, again, we'll just have to wait and see. Following Baldwin, the only case to further discuss this.
Oops, I have one more Baldwin, I'm sorry.
All right, I'm sorry, go ahead.
So after the Supreme Court answered the certified question that yes, in fact, there is qualified immunity, defendants could assert qualified immunity as a defense. The case goes back to Judge Bennett. Now, Judge Bennett says, well, wait a minute, the only defendant left when the court answered that question was the city. I just asked defendants, so of course the city, as the city defendant, can assert qualified immunity. Baldwin says, no, that is only for individuals. So once again, there are more certified questions to come. It is interesting to note that when Baldwin goes back to Judge Bennett on the summary judgment motions that come in next, the city actually abandoned its motion for summary judgment on qualified immunity and said that disputed facts exist to preclude Baldwin's motion for summary judgment. The court disagreed, however, and ruled that because of Iowa court's ruling that there is no good faith exception to the exclusionary rule, and because the Iowa court has already ruled that mistakes of law cannot justify a stop, that Baldwin was entitled to summary judgment on his Section 1 and Section 8 constitutional claims. However, it still left open the following questions. So currently these questions are certified to the court, and I think briefing is just starting. So question number 1, can the city assert qualified immunity to a claim for damages for violations of the Constitution based on its officers' exercise of, quote, all due care? Question number 2, if the city can assert such a defense, does the city have all due care qualified immunity to liability for damages of the violations of the rights that the individual officers had? And Judge Bennett said this question necessarily includes questions about the extent to which reliance on a warrant may satisfy the all due care standard, and whether the all due care analysis considers alternative bases for probable cause or a warrant that the officers actually did not rely. Question number 3, if punitive damages are available for remedy against an individual defendant, can punitive damages be awarded against a municipality that employed the individual defendant, and if so, what standard? Question number 4, if punitive damages are available, would a reasonable jury be able to find that the applicable standard was met on the facts presented in this case? So basically, Bennett is punting to the Iowa Supreme Court, like, give me all of the answers. And then number 5, if an award of attorney's fees would have been available against individual defendants for a plaintiff who attained some degree of success on a constitutional claim, would they be available against a municipality? So a lot of the questions that we believe are left unanswered from Godfrey may have some answers in this case, although it's yet to be seen.
And personally, I think certified questions are a really kind of unfortunate way that this area of law is being advanced right now, because certified questions are, while they take place in a case, are written somewhat hypothetically with the purpose of wider application. And I think this is an exceedingly fact-driven case. It's an exceedingly fact-driven area of law. And I think with an undeveloped record, and then a record that the Iowa Supreme Court has only seen part of, really puts, I think, both the court and all of us at a disadvantage to understand where this area of law is going to go in the future.
Yeah, and the distinction between individual defendants and the city defendants, I think, shows that unfortunate status. I mean, if the court really didn't realize that the only defendants left was the city, and they were talking about qualified immunity for individuals in a question that was really just about a municipality liability, it seems that we weren't even talking about the same apples here.
Now, interestingly enough, there was another Godfrey type issue raised in a Wisconsin federal district court. However, that court determined, after it had likewise dismissed all the federal claims, to dismiss the remaining claims for want of federal jurisdiction, because this area of law was so undeveloped that that district court judge didn't want to touch it, and sent it back to be developed in state court. Following the Baldwin cases, the Iowa Court of Appeals recently came out with another application of the immunity question in Godfrey cases, and that is in the Lynette case. Mr. Lynette sued the state of Iowa and several employees with the Department of Human Services as the result of a China action involving his children. Lynette alleged the rights violated included liberty, property, privacy, procedural and substantive due process, rights in the parent-child relationship, and in avoiding physical and emotional harm. The Court of Appeals doesn't articulate the corresponding constitutional provision for all of those claims. So then the issue in Lynette was that the state had filed a motion to dismiss based upon qualified immunity. Unfortunately for the state, Baldwin had come out in the months in between its appeal briefing and the oral argument, and so the state had to concede at argument that whether qualified immunity existed was an affirmative defense and thus not properly raised in a motion to dismiss. So while Lynette at first kind of shocked me, it really just is a direct application of Baldwin, and I don't think sets forth a lot of new standards. I would say that I was pleased to note in the discussion that the Court of Appeals had, it's clear to them they understand the Godfrey distinction, that at this time, at least, only some provisions are determined to be self-executing. So I think the Court of Appeals has signaled that it would be welcoming of those arguments based upon other constitutional provisions.
Yeah, and I agree. When I read Lynette at first, I thought it was a dire indication of where we might be going for qualified immunity. But upon closer analysis, I mean, qualified immunity is generally something that you can only raise on summary judgment anyway. So I don't think this case changes the course of defense at all. Of course, both Baldwin and Lynette show how important it is to raise qualified immunity as an affirmative defense. But I don't think it really changes much in the course of a defense in one of these cases.
I agree. So we're running out of time. To wrap up, I think what we wanted to convey to you, if you get a Godfrey claim, look at the constitutional right as asserted that was violated. Is it self-executing? And then are there common law immunities and statutory immunities that can be alleged? Now, this is kind of, while those are three questions, this is really, oh, and I actually forgot one of them. Whether or not there's what constitutional claim, is it self-executing, is there a comparable civil remedy, are there immunities? Now, the tricky thing is, those four issues, some are going to be raised in the motion to dismiss, some are going to be raised in summary judgment. I think that setting up your litigation that way is important. We all know motion to dismiss in state court will never be granted, even in.
Now, Megan, never is a little harsh.
Okay, I think I got one.
Almost never.
Perhaps, in my life, granted in state court. But it does set up, and it makes the plaintiff pick their lane. And it does, the judge's ruling on the motion to dismiss, I think, replaces the petition of what is this case going forward. And so I think you can use your motion to dismiss to narrow what I think are really kind of squishy claims being raised by the plaintiff's bar right now.
So we can open it to questions if anyone has any questions or comments on, or, theories about what they think, where they think the court is going to go with this.
Well, we haven't really, we've had this issue arise in a bunch of cases so far, but where we've really seen this arise is in plaintiff attorneys attempting to use the prospect of a Godfrey claim as a wedge issue to get a more favorable result for a settlement for their clients in traditional cases. So we haven't seen a flood of Godfrey cases. I know of several around the state that we're watching right now, but it is well known in its existence and people are trying to use it in whatever way they can right now.
Thank you.